The judge presiding over former President Donald Trump's federal trial delivered one of the most direct and forceful instructions heard in a courtroom in recent memory. Stop the nonsense right now and sit quietly in your seat. This sharp, no-nonsense moment occurred today during what has already been described as one of the most intense and closely monitored legal proceedings in modern American history. The federal courthouse in Lower Manhattan felt electric with tension from the moment the session began. Every seat in the public gallery was filled, journalists scribbled furiously, and the overflow media room down the hall buzzed with live commentary. Everyone understood that today could bring pivotal developments, and it did, though not necessarily the kind many had anticipated. According to detailed pool reports, courtroom transcripts, and accounts from multiple journalists and legal observers present, former President Trump had been reacting audibly during key portions of the testimony. At times, he muttered comments under his breath when a prosecution witness spoke. At other moments, he appeared to shake his head noticeably or let out quiet but audible expressions of disagreement. Gestures that, while subtle to the untrained eye, were clearly visible and audible to the judge, the jury, and everyone else in the room. After several such instances accumulated over the course of about 45 minutes, Judge Patricia Caldwell, widely regarded as measured, meticulous, and unflappable after more than 3 decades on the federal bench, paused the proceedings. She removed her glasses, looked directly at the defendant seated at the defense table, and addressed him personally in a calm, clear, and unmistakably authoritative tone. Her words, as captured by the official court reporter and immediately relayed by every major news organization covering the trial, were straightforward and left no room for ambiguity. Mr. Trump, I will not repeat this again. You will stop these interruptions and commentary immediately. You will sit quietly and you will behave appropriately in my courtroom. This is not a rally. This is not a press conference. This is a court of law. Everyone here, including you, is expected to follow the rules. Do I make myself clear? The courtroom fell completely silent. Several reporters later described the moment as one in which you could hear the air conditioning for the first time all morning. The former president, who had been leaning slightly forward with his arms crossed, slowly sat back in his chair, nodded once, and folded his hands on the table in front of him. From that point forward, according to everyone present, he remained silent for the remainder of the afternoon session. Legal analysts appearing on cable news within the hour called the judge's intervention unusually direct but entirely justified. One former federal judge, now a frequent commentator, explained, "When a trial judge has to speak directly to a defendant about courtroom behavior, it usually means the defendant has already crossed several invisible lines." Judge Caldwell waited until the pattern was unmistakable, then addressed it head-on with language that was plain, professional, and impossible to misinterpret. That's exactly how a strong trial judge handles this kind of situation. The broader context makes the moment even more significant. This trial involves extremely serious felony charges tied to alleged financial misconduct, falsification of records, and attempts to influence official proceedings. Prosecutors have spent weeks methodically building their case through documents, bank records, encrypted messages, wire transfers, checks, invoices, and the testimony of cooperating witnesses who once worked closely with the defendant. The defense team has fought every step of the way, challenging the authenticity of documents, the chain of custody, the relevance of certain conversations, the credibility of witnesses, and even the legal theories the prosecution is relying upon. Objections have been frequent and vigorous. Rulings have sometimes gone against the defense, occasionally prompting visible frustration at the defense table. Today's session was particularly combative. The morning featured extended arguments over the admissibility of a set of previously sealed communications. Midday brought the testimony of a former senior executive who has been cooperating with the government for many months. That witness described in granular detail a series of meetings, phone calls, and written instructions that prosecutors say directly implicate the former president. It was during this testimony, when the witness recounted specific conversations and decisions, that the defendant's reactions became more frequent and more noticeable. Legal experts believe this may explain why the judge chose this precise moment to intervene. The testimony was among the most potentially damaging the jury had heard so far, and any disruption at that point carried heightened risk of influencing the panel. After the judge's instruction, the session continued for another 2.5 hours. The defense cross-examined the cooperating witness aggressively but methodically. The prosecution presented additional documentary evidence. Throughout it all, the former president remained seated, silent, and composed, exactly as the court had directed. Reactions outside the courtroom were immediate and sharply divided. Supporters flooded social media with messages claiming the judge was biased, heavy-handed, and attempting to intimidate the defendant. Several prominent conservative commentators described the moment as judicial tyranny and election interference disguised as courtroom management. Conversely, many legal scholars, former prosecutors, and moderate political voices praised the judge for protecting the integrity of the process. A statement from the American Bar Association's Judicial Conduct Committee, while not directly commenting on this case, reminded the public that trial judges have broad discretion and indeed a duty to maintain order and decorum regardless of who is sitting at the defense table. Security around the courthouse, already at elevated levels for weeks, remained exceptionally tight. Additional barriers were in place, and uniformed officers were more visible than usual. Authorities have repeatedly stated they are prepared for any potential developments as the trial moves toward its final stages. What lies ahead is daunting for everyone involved. The prosecution still plans to call several more high-profile witnesses, including individuals with direct personal and financial knowledge of the events in question. Closing arguments are now estimated to be only a few weeks away, assuming no major delays. Jury deliberations could begin before the end of February. Today's incident, though brief, will likely be remembered as a defining moment. It reminded the nation of a fundamental truth. In a courtroom, no one, not a former president, not a billionaire, not a celebrity, is exempt from the basic rules of behavior that apply to every citizen. Judge Caldwell's calm, unequivocal command to stop the nonsense and sit quietly was more than a correction of one man's conduct. It was a reaffirmation that the judicial process, no matter how politically charged the case, must remain focused, fair, and orderly. The trial continues tomorrow morning at 9:30 sharp. Every word, every ruling, and every gesture will be watched with intense interest. This is not just a legal proceeding anymore. It is a test of whether the institutions of American justice can withstand extraordinary pressure and still deliver impartial results. We will, of course, bring you every significant development as it happens. Stay with us. This story is far from over, and the next few weeks promise to be among the most consequential in recent memory.